The ACLJ will represent South Dakota and Governor Noem against Planned Parenthood, and a judge in Texas has just rejected the DOJ move to block the Texas abortion law. First, out of South Dakota, you might have seen Governor Noem, if you follow her social media accounts, Facebook or Twitter, you might have seen her press release out. But the ACLJ is going to be representing Governor Noem and the state of South Dakota in their battle against Planned Parenthood. And in their law, different from Texas, this is a law that requires an informed consent level where you need to go, if you want to seek an abortion, you need to go to a third party for to get information about what the procedure is, what you're about to do. That not just Planned Parenthood is the one who provides the informed consent. It's another unique law, like we saw in Texas, and it ties right into that. Because a Obama-appointed district court judge in Texas today just denied the DOJ's request for an expedited briefing schedule, did not enter an injunction yet, is not even going to hear the issue of an injunction until October 1st. So still, now you had the Planned Parenthood challenge, then you had the DOJ challenge. Both so far have not been successful. What does that mean? That law in Texas, the 6-week abortion ban, the heartbeat ban, that continues to be enforced.
Yeah, what's interesting here, Judge Pittman said that before the court is the United States, that's the Department of Justice, opposed motion for expedited briefing. In other words, they wanted to expedite this to get an emergency order. And the court said nope, that this case presents complex, important questions of law that merit a full opportunity for the parties to present their positions to the court. Accordingly, it is ordered, this is big, that the United States opposed motion for expedited briefing schedule is denied. Now, that's not a merits decision, understand that. But what it does tell you is that the court, at least at this point, Andy, is not looking at this law as if it is per se unconstitutional.
No, because, a lot of times judges will signal ahead to you by their rulings, yes, preliminary rulings, what they're intending to do. And if this was something that had to be expedited, he might have said it's granted and we're going to expedite the review. But he didn't do that, which sends a signal. I don't know what it is. You never know what a judge is going to do, but it sends a signal that gives us hope, and that's what we want.
Yeah, CC Hiles with us, senior counsel for the ACLJ. It's interesting to me, Planned Parenthood, no matter what is done with abortion, whether it's like we're dealing with in South Dakota in a major case, we're going to get into that a little bit later, where it's just counseling before you get an abortion to prevent coerced abortions. Even things like that, Planned Parenthood every single time objects.
Absolutely. These are just common sense protections, and they're constitutional. Like you said in South Dakota, it is absolutely an informed consent bill, and yet Planned Parenthood is going to go after that. It's informed consent. Someone who's going to have a medical procedure needs to know what they're getting into. And once again, Planned Parenthood comes against that. And so every single time you have anything that's going to protect life, any kind of bill that's going to protect life, we can absolutely expect that Planned Parenthood is going to challenge it.
That's kind of their modus operandi. If there's a bill been passed that protects life, we challenge it.
They used to be able to kind of, I think, assume that they were going to find judges on both sides of the aisle, actually, that would just do their bidding. They'd file, and they'd get what they want.
So this Fifth Circuit case, people need to remember, went all the way to the Supreme Court.
Yeah, the Supreme Court told Planned Parenthood no. Now the district court judge has told the Department of Justice no.
Right.
So you've had the DOJ intervene, and they were told no. So we come back. We're going to get into the South Dakota case. ACLJ is representing South Dakota and Governor Noem. There was a press release that went out, but we want to get into the details there as well, and we will be right back on Sekulow. Welcome back to Sekulow. One question we wanted to ask you, and again, this is only if you're willing to share, but would laws like this, would a law like in South Dakota that required you, before you went to go get the abortion, to go talk to somebody's third party, so it wasn't just talking to Planned Parenthood about whether or not you should get an abortion, it's in their financial interest for you to get an abortion. They want you to do it because of the money they make. So to go to a third party and then make up your mind on your own, would that have changed potentially your decision to have or not have an abortion? Give us a call, 1-800-684-3110. Also in Texas, something a little different. In Texas, when hearing the heartbeat, would hearing that heartbeat of the child have stopped you from buying into, and especially the 70s, 80s, even the 90s, this idea that this is just a cell, this is just tissue, and no big deal. Whereas most people aren't even going to the doctor to see if they're pregnant until around the time the heartbeat is already there,
Exactly.
and because of the technology we have. So I'd love to hear from people if they think this would have changed their decision, having these opportunities that were basically kind of mandated, that you've got to, one, you can't have an abortion past the heartbeat, and then second, that you've got to go talk to somebody. Doesn't mean you can't have an abortion. It just means you have to go talk to somebody to walk you through what you're about to do.
Right. So let me talk for a moment about South Dakota, because it really is an honor for us, for the ACLJ, to be representing Governor Noem and the people of South Dakota in a critically important case. One is common sense case that will protect the well-being of the mother and the unborn child. Ultimately, that woman could still decide to have an abortion. There's nothing in it that prevents abortion. The bill just simply says, look, if you're about to have an abortion, before the informed consent from Planned Parenthood is not enough, because they're in that business. We want you to go to a third party, unrelated, licensed, and talk with them. And they can't, it's not a faith-based thing. It is just going to talk to somebody about the consequences of abortion, what are the risks of abortion, what are the options on abortion. Common sense on a medical procedure like this. This is the only medical procedure where a life is taken. I mean, Cece, I reiterate that over and over again. You cannot compare this. People say, well, if I go get a tonsillectomy, I don't have to go to a third party to get my tonsils out. But it's interesting. You can't just go to your general practitioner and get your tonsils out. You go to a specialist. They give you informed consent. But they're not ending another person's life. So the abortion procedure itself is unique among any procedure, any medical procedure. And Cece, the states are starting to get very creative on how to deal with this. They're not banning abortion here. They ban it in Texas. What they're saying is we are going to put in common sense approaches on this issue.
Yes, and I think the informed consent approach is more than appropriate. You mentioned getting your tonsils out, but you do get all of the information from the doctor about what could happen. You might die. There might be, they will give you all of that information. When you go to Planned Parenthood, they do not give women that information. They do not give them the information where a pregnant woman can make an informed decision.
Well,
so again,
to be fair, they say they do give it. This is what they say, Cece. They say they give informed consent. But their version of informed consent and what we're talking about as informed consent are two different things. They say they give informed consent.
Absolutely.
It's just not really informed.
That's exactly right. It's very limited of the information they give. They don't want to let you see the baby. They don't want to let you hear the heartbeat. They don't tell you about all the problems that can happen. And we've had women call in to our radio show and say, they just ushered me through. They didn't tell me what was going to happen. And that's why you see so many people come out of abortions that are crying, because they realize what they have done after the fact. They need to have that realization before the fact. And that's what this informed consent law does.
You're exactly right.
I asked people to call in and share with us if they're willing to, whether or not this would have changed their decision involving an abortion they may have had, and especially the time periods of 70s, 80s, 90s, when you're not getting information and you were just told this is no big deal. You can use it like birth control or whatever. Don't worry about it. This is wonderful. And then, of course, the science wasn't there to show you what was in the womb or show the heartbeat yet.
Boy, the science is there now.
But Carolyn from Georgia is calling in to talk to us about that very issue. Carolyn, welcome to Sekulow. You're on the air.
Hi. This is so good. I thank you guys for what you're doing. First of all, I praise God for this knowledge and pray that it will help someone that's possibly considering an abortion. It's a life, and I am humbled to be able to speak with you guys about this. Thank you.
Okay. Well, we appreciate you calling in. You said that if you had this information available, you would have made a different decision.
Absolutely.
This is why, when I look at these laws, you gotta kind of put on both hats. You got to put on your lawyer hat, and then you got to put on your policy hat. And the lawyer hat says, well, can I defend this law constitutionally? I think we think we can. That's why we're taking the case. And it's a big deal representing the state of South Dakota before the 8th Circuit Court of Appeals. A number of our lawyers have been appointed special deputy attorney generals to do this. But on the other hand, Harry, there's a policy question. The policy question that I keep raising is that this is unique among any other procedure. This is the taking of a human life. So what is the harm constitutionally if you say, you know what, before you have this procedure where you take this human life, because as Jordan said, you cannot argue it's not a human life anymore. They don't even argue that. I mean, that's when they're selling fetal parts. They're talking about baby body parts. Right. So, look, we know what they're talking about here. But from a policy standpoint, aren't these new approaches common sense approaches to how to deal with this?
You're absolutely correct. They are common sense approaches. But that is precisely what Planned Parenthood opposes. They oppose the Texas law. Why? Because it's very, very unique. It allows citizens to bring a cause of action to protect human life. And what is Planned Parenthood all about? It is about actually shrinking human life throughout the world, not only in the United States, but throughout the globe. And so if you look at Planned Parenthood v. Casey, a seminal decision by the Supreme Court, what did the Supreme Court at its core decide? It decided that it was going to elevate or reify radical human autonomy. This is basically what Planned Parenthood is all about. They want to reify and elevate the moral Darwinism that supports eugenics, which then supports the shrinkage of human life. And there are many individuals who are connected with, for instance, the so-called global warming issue, who want to reduce the number of human lives that are on the globe. And so this all ties together. And so I think at the end of the day, the real issue is why won't Democrats who used to stand up for human life, all sorts of human life, the weakest among us, now they are standing with Planned Parenthood in its pursuit, its venal pursuit of profits.
Because if a Democratic candidate for president even mentions a possibility of a abortion restriction being constitutional, I would talk like Tulsi Gabbard and Andrew Yang. They were out the next week. That was it.
Yeah. Let me just say this to all the activists out there. I know a lot of you listening would consider yourself an activist. The pro-life movement has done an excellent job of getting pro-life leaders elected, where you can't rise through the ranks of the Republican Party if you are not pro-life, and if you're not willing, especially if you're a governor. So you've got the state ability to assign laws, work with the state legislature on pro-life legislation. That's why we're seeing it from across the country in different places, whether it's South Dakota or Texas or Mississippi with the case that will be up before the Supreme Court, all different things. One is like a 15-week out of Mississippi, a ban, and then you've got the 6-week issue out of Texas, and you also have, of course, in South Dakota, the informed consent issue of utilizing a third party. That's all happening. Those are 3 Republican governors, 3 states that were willing to take novel approaches to fight back against Planned Parenthood and the abortion industry. Yep. And I don't like always making it so partisan, but that's just the way we are right now. I mean, if you
we used to have Democrats, Jordan, on our briefs to the Supreme Court.
There was a period of time.
It wasn't 15 or 20, but it was 5 or 10.
Yeah, there was a period of time. But I just want to say, it's a big thank you to the activists out there who are in the states who make those decisions in the primaries to elect these officials that are electing really solid pro-life candidates to their state's highest office, who are willing to do and go to battle against Planned Parenthood or even the Department of Justice like we've seen here. So a lot to talk about. Again, we have been appointed by Governor Noem to represent the state of South Dakota in their case against Planned Parenthood. The question that we asked was, if these laws were in place, would you have made a different decision about abortion? You have to remember, when abortion was legalized by Roe versus Wade, It was marketed towards women. And by the way, religious communities were not opposed. The Catholic Church was.
Not anybody else.
But the Protestant churches were not engaging the issue, sometimes even supporting Planned Parenthood in these health clinics and abortion. So we asked the question to our audience, would these kind of laws have potentially changed your decision about having an abortion back in that time period where there was no informed consent, there was no way to hear the heartbeat at 6 weeks, to see the development of the child at even 15 weeks you wouldn't be able to have seen. But now what Planned Parenthood does, that technology exists. They don't want people to be able to utilize it.
That's exactly right.
So let's go to the phones. Christine in Texas on line 1. Hey, Christine.
Hi, how are you?
Good.
Well, many years ago, I was a rape victim and talked to my aunt. She took me to Planned Parenthood. I went in there looking for options. I really didn't want to murder a baby. I didn't really understand that it was murder, but never did they want to discuss any options with me at all. It was just, this child would destroy your life. It'll be a hindrance. You will never be able to accomplish anything in life. And that was it. I mean, there was nothing. And I'll never forget the day that the abortion took place, to hear that baby sucked out of my body. And it wasn't until years later that I came to the saving grace of God that I realized it was murder.
Well, I really appreciate, Christine, you calling, because when we look at these cases, that's what we as a team have to look at. CC, me, Jordan, Andy, Harry, everybody, our whole Walter Weber, everybody working on these cases. And what is really true is their version of informed consent in your case sounded like you're going to be burdened by this child. They didn't give you the options on adoption. They didn't give you the option, I'm assuming. But what South Dakota's trying to do, Andy, is simply say, before you have this procedure, which they allow to have, you're going to go to a third-party counselor licensed by the state and get counseling so you know what you're doing.
I don't see what's wrong with that at all. I don't understand what the objection is, except it's the knee-jerk reaction of Planned Parenthood to anything that smacks of preventing, in any way impeding abortion. Here is a law, very ingenious and very well thought out, that says go to a third party. Don't go to any party who's advocating one way or the other. Get advice and counsel. Take a common sense approach. Have informed consent, because as you said earlier,
they could decide yes.
Abortion. Yes, you could decide ultimately I want to have it no matter what.
Right.
Thank you. But now I know. But as our producer said, and I think this is important, this is the agenda of the left. Follow the science, they say, but not when it deals with abortion.
How big, Ian, because you've been a state attorney general before, how big is it for the fact that the state of South Dakota has made us special deputy attorney general?
I mean, that's huge. I mean, I was a special assistant attorney general in Georgia for many, many years under Democratic and Republican administrations. Yep. But it's a big thing for the state to go out of its own wheelhouse and to choose outside attorneys to be special assistant AGs or deputy AGs to argue these cases on behalf of the state. It's a very great honor, it's a very great privilege, and it's a tribute to, I got to say it's a tribute to us that they picked us to do this.
Well, I said in a press release that on behalf of the ACLJ, and I'm going to say it again, Jordan, I am honored, we are honored to represent Governor Noem. We are honored to represent the people of South Dakota, and this common sense legislation is going to protect mothers and children. It doesn't mean CC, that they're not going to be able to get an abortion, because they could decide after hearing all the options and having real informed consent, they still want to proceed. They're allowed to do that under this law. But at least it will give a form of informed consent so we find out if these are coerced or not. Because oftentimes it can be a coerced situation.
Yes. And as we heard even during the break, you don't want to realize that you've killed a baby after the procedure. They need to realize what's going to happen before they have the procedure. And that just does not happen in Planned Parenthood. So we need informed consent, true informed consent. They need counseling. They need to know what is going to happen when I go in to have an abortion.
You know, I think that, again, I want to take more calls here. This is an interesting one, too, from Sarah in California. We talked about Planned Parenthood in the schools before. This has been an issue as well. That the Planned Parenthood counselors going into public schools. Hey, Sarah, welcome to Sekulow. You're on the air.
Hi there. I just wanted to ask a question. What can I do, or what can we as constituents do? Because I remember them coming into my high school.
Yeah.
And I know friends that did have abortions because of the information they gave them. And is there something that we can do to, like, put it on a ballot so that there could be, like, pregnancy crisis centers who come in, or people from, like, I know Live Action, who has their videos, and they inform people what the procedures are, so at least the students understand that it is a baby.
Yeah.
And it gives them more informed consent of what they're doing and participating in, and it's not just a blob inside of them.
You know, Sarah, I think that one of the things I've never quite understood, and I've litigated these cases for 40 years, if you let one side of the debate into the school, Harry, you let one side in, then under every Supreme Court case we argued for 3 decades, and we won most of them unanimous, 8-1, 9-0, you have to let the other side have their viewpoint. But it seems like Planned Parenthood's given the free pass into the schools, and everybody else gets hit with church-state separation. We can't allow the pro-life crisis pregnancy center in there. And in California, especially onerous, because Javier Becerra, who's now the head of HHS, was trying to make the crisis pregnancy centers say, here's where you go to get your abortion.
I think you're precisely correct. So we now live in an age where there is a governmental ministry of truth, in which only one side of the argument is allowed to present its perspective. You see this with respect to the Biden administration. You see this with respect to the critical race movement. You see this with respect to a lot of progressive, so-called progressive ideas. And you see this even with individuals who claim that they are following the science. So we live in an age where people say, follow the science with respect to climate change, but then with respect to certain other issues, they say, oh, it's just a matter of choice. So I think at the end of the day, one of the things that we have to fight very strongly in favor of is we need to fight in favor of the truth and allowing individuals to make their own decision once they've been presented with the truth. And the truth means that people need to hear, at the end of the day, both sides.
That's exactly right. And they don't want that.
No, they don't. That's what they fight against. And they've in the past been successful, but they are starting to run into some new roadblocks because of the courageous governors and state legislators out there, and also the courts. There's been a shift in the courts. The Trump administration appointed a lot of new judges all the way up through to the Supreme Court, but a lot of district court, a lot of appellate court, and you're starting to see a different view, a different way of analyzing these restrictions or informed consent rules or heartbeat rules, all of that. It's coming to a different, people are looking at it differently.
You know who was my co-counsel? You'll remember this. My co-counsel in a case involving pro-life protests in the 1990s? John Roberts, now the Chief Justice of the United States Supreme Court. He was my co-counsel in 2 cases at the Supreme Court. How about that, both involving abortion?
I will say one other quick thing before we go, though, Jay. You know, we live in a country where so many people claim to be woke, and we have regret for societal actions in the past. We repent for the deeds of our ancestors. I think 100 years from now, less than that probably, people will look back on this whole abortion issue, and there will be real shock and horror of what we've done for the last 40 years.
And that this happened in the United States of America, because now when you see those ultrasounds or the imaging that is done, and that's why I go back to Harry really quickly, it really does change the debate.
Absolutely. And I think one of the things that ultrasound does is it completes informed consent.
Exactly.
Because people now have more information and they realize that a life is at stake.
I want to end this broadcast with understanding that your American Center for Law and Justice has been appointed special deputy attorney generals for the state of South Dakota for this pro-life case, this abortion case that is going to the 8th Circuit Court of Appeals. Andy, this is a big deal.
That is extremely high honor. Usually states handle these things in-house. They handle it through their attorney general's office, but the attorney general of the state of South Dakota has appointed the ACLJ and its attorneys to represent the governor and the state in this important case that is pending in the Eighth Circuit, or soon will be, or is pending in the Eighth Circuit Court of Appeals, and will probably most likely go to the Supreme Court of the United States.